All right, Paul Hansen wanted this read into a YouTube video for the public record. It's on case number 3:14-CR-00091-MCR. MCR stands for that wicked judge, Margaret Casey Rogers, or Margaret Catherine Rogers. It's document number 246 in that case number. So it's about 13 pages. And if you're interested in the case of Paul Hansen, I will be reading what he wrote. It's written in pencil on a piece of paper because he's writing it in prison. And I'm abiding by Paul Hansen's wishes, and here goes. USA versus Hansen. Related motion to alter or amend judgment, August 21st, 2015. Sentencing ruling with notice of law, pursuant to all applicable U.S. law. Klotz is to add here. I am seeking a more reasonable sentence to match the actions. I wish to show that time served would more than suit the actions of Hansen. With 18 months, I am greatly hindered in formulating my appeal. The U.S. has paid $313,000 on prosecuting this case. So says the FOIA request we ordered. Adding $80 per day is an unnecessary burden on me and the American people. I have served 10 months already, and now I have 8 more. 8 months at $80 per day is $19,200. This case has and is and will get millions of hits on the internet. I and Kenthoven will travel the nation not only by the World Wide Web, but also in person for the next 20 years, showing the people how Kent was framed by IRS agents, U.S. attorneys, U.S. judges, and even his own highly paid attorney. I personally believe each and every person knows that Kent was 100% innocent in the 2006 case. For sure, God knows all. The people are going to take it back to court, for all of Kent's acts took place on land not of the U.S. pursuant to Article 1, Section 8, Paragraph 17, I think, U.S. Constitution. This will be a public hearing, not U.S. government controlled, God willing. Though both charges, jury judgments should be vacated as a matter of law, notwithstanding the 18-month sentence should be reduced for the following reasons. Count 5. Mailing a letter to a title company attorney to notice him of the trust interest in what we believe is legally church property. 1. All of my mailings were from into to land not evidenced as land of the United States, and all acts of communications. 2. I was arrested on land not evidenced of the United States. 3. U.S. warrants are limited to have force only on U.S. land. 4. U.S. jurisdiction is limited to land outside of the 50 states. C 18 USC something 7. 5. Hansen is not evidenced as electing to become a U.S. citizen. C 8 USC 1421 open parenthesis D close parenthesis. 6. Hansen is not evidenced as electing to become a resident of the U.S. Page 4. Number 7. Hansen is not evidenced as having any contract with the United States that the United States can use to create personal jurisdiction over him. C. Hagens versus Levine, 415 U.S. 533 N-3 Note 5. Once jurisdiction is challenged, it must be proven by the plaintiff. C. Owens versus City of Independence 100 SCT 1398-1980. The mere good faith assertion of power and authority, jurisdiction, have been abolished. Number 8. U.S. written law and court orders, warrants, only have force and effect of law only outside the boundaries of land belonging to any of the 50 states. See 18 U.S.C. 7. Territorial jurisdiction of the, page 5, United States extends only outside the boundaries of land belonging to any of the 50 states. The above can and will be soon before a common law jury on the front steps of the federal courthouse if need be. I have been told that head prosecutor Pamela Marsh resigned the day before my sentencing hearing on 8/21/15. This is suspicious that she walk at this time. That is the fourth prosecutor that resigned upon receiving my jurisdictional challenges. Note, none have been heard on their merits, not one out of many. Due to Kenthoven's 60 million plus hits on YouTube, it is imperative that the American people will eventually have such an outcry that it will explode into a media frenzy. Page 6. That may last for years with authored books and movie productions, if not on the main medias. It will touch tens of millions more by the internet, aided by thousands that want the rug to be lifted and all shown. The people will ask, how can one get 18 months for a letter that has had no effect on anyone or anything? The people will also ask why the government will not document the law that allows them to not be required to prove they have no legal duty to prove jurisdiction for both count 5 and 6. The People's Community Common Law Court has the authority to force the U.S. agents to evidence their law relied upon. If not, the court can assess damages to each man accordingly. This common law court is a biblical court and is enforced by God. A prudent person stops damaging when wisdom guides. Every day I am falsely incarcerated. Page 7. I will seek $3,600 for damages, more if conspiracy is evidenced. The wisdom of the plowboy will be before the jury. It will not go well for many. If any man reading this wishes to confess wrongdoing for conscience sake and leniency, do so in writing to me ASAP. If your superiors have compelled you to do these wrongs to Kent or me, I ask that you disclose their demand expediently. All acts done by any U.S. agent that is outside of the written law are subject to the people's jury. Every juror in the case who has not participated in an oath process is not therefore a legal U.S. citizen, thus not a qualified juror, and has a duty to report so. How the U.S. agents have conspired to falsely prosecute Kenthoven in 2006 is disquieting at the least. These acts have done much harm. Each will be drawn out into the light by the tool called Number 8, page 8, the People's Common Law Court of Record, Court. These questions must be answered. Number 1, does the U.S. have a man that will claim that the location of Hansen's arrest by warrant operate as a matter of law at the arrest location? Number 2, does the U.S. have a man that will claim that Hansen mailed a letter on or into land that is outside the 50 states, pursuant to 18 U.S.C. Section 7. Number 3, does the U.S. have a man that has evidenced that Hansen did an act that gave personal jurisdiction over Hansen? Number 4, does Scott Snyder, IRS agent, have evidenced that Kenthoven had a duty to withhold taxes from church ministry workers in 1995 to 2006? I recommend that all involved contact Judge Rogers, MCR, and ask that the case be vacated or at a minimum that the sentence be changed to time served. Page 9. More on count 6. More on count 6, contempt. Fail to appear for fingerprints. Number 1. First, I noticed, challenged by email, that I wish to have what the U.S. has in written law, that I am a person, fiction, in 18 U.S.C. section 401, and does the U.S. have a man that will claim by his personal commercial liability that I am a person as defined in said chapter 18. This same challenge I am yet denied by this court. If it cannot be evidenced now, it too was lacking then. Number 2. Second, my fail to appear had no effect on the case or on any gathering of evidence. No delay, none, nada. The U.S. already had on file 20 full sets of my fingerprints prior to this. It is a fallacy that they needed more. My prints, they just wanted to harass me, so said all my lawyers. The U.S. even now must prove I was a person and had a legal duty as a matter of law. Page 10. Not a matter of jury. To appear, they also must prove they had no duty to tell me the authority they rely upon to force me to appear in Florida, as it was not of my jurisdiction. Number 3. Miss Rogers had a duty to give findings when I challenged personal, subject matter, and territorial jurisdiction. I had a right to those findings. I may have remedy in a court of record for the damages caused if I in fact was due the findings. The day Scott Snyder, IRS agent, is questioned under oath without the blockage of U.S. judges, the top is going to be blown off both the 2006 and 2014 cases. Much written here is for future litigation evidence. I did no crime, and all my acts were compliant to God's law. Page 11. When any man violates another man's rights, that man is warring against God and faces God's judgment. The legislative intent of 18 U.S.C. 401, contempt, is to meet the needs of justice. It was never intended to imprison a man 18 months when, number 1, no damage occurred, number 2, no lien was filed, number 3, no cloud was created, number 4, no effect on the case, number 5, no delay of any type, number 6, no attempt to cloud or file a lien is evidenced, number 7, no cloud or lien need to be removed, number 8, yes, the court refused to give Hansen the law relied upon, number 9, yes, the court is attempting to make it policy that a man like Hansen cannot mail a notice for future litigation. The law common of old would be I pay restitution for all. Page 12. I pay restitution for all damages that my mailing caused. Let's add up those damages. 1 through 7 equals 0 damages. The intent of 401 has been converted to a no-effect law that can land you in jail for years. Intent of the legislature is the law, not the misapplication of it. The law of Christian nations only punishes true crimes, true damage, and unlawful policies. General Christianity is and always has been a part of the common law. The People versus Ruggles, 8 John's 290. Intent is always the spirit of the law of the legislature. Judges should never imprison men when no crime occurred. They should not ever just because they can. This should never be allowed as policy. Page 13. I have been tortured, jailed for 11 months now. Jailed with profane, base-minded men poor food, little room to even walk. I see clearly why God never, not one time, instructed man to imprison another man as punishment, not to be used to create jurisdiction. Wherefore I motion the court to obey God, not man, to reduce the sentence to time served, first on count 5 and second on count 6, for the multitude of reasons listed above. August the 30th, he writes 2014, but I'm pretty sure it's 2015. Paul John Hansen, verifiable proof of mailing. I have caused this motion to be mailed to U.S. District Court, 1 North Palafox Street, room 226, Pensacola, Florida, 32502 on August at 4 p.m. Paul Hansen. U.S. Attorney Counsel Chris Klotz. Okay, that's the reading of Paul Hansen's motion to alter or amend judgment. It's document number 246. I know that there are those in the enemy camp that absolutely are laughing and they are ridiculing Paul's motion. I'm sure they did the same thing to Noah as Noah was building the ark. I'm sure they did the same thing to David before David killed Goliath and cut off his head. And I'm sure they did the same thing to Shadrach, Meshach, and Abednego as they were throwing those 3 gentlemen into the fire, and they were trusting in the Lord. So you guys go ahead and laugh at Paul Hansen's motion, and when God Almighty takes the throne again, we'll see what God Almighty does with Paul Hansen's motion. I can't wait to see judgment from God Almighty on this entire situation.